Good morning. I'm going to call to order this regular meeting of the Zoning and Planning Committee for the Thursday, March 29th. My name is Jeremy Schrader, and I'm the chair of this committee. With me at the dais are Councilmember Ellison, Councilmember Wright, Councilmember Goodman. Let the dais reflect that we have a quorum. We have 5 items on the agenda today. Before going into our public hearings, I'd like to handle the consent agenda. Number 3 is the approval of an application submitted by JWT Lake Street, LLC, for the rezoning of properties located at 1715 1717th Lake Street East from C1 Neighborhood Commercial District to C2 Neighborhood Corridor Commercial District to allow a grocery store with a tobacco license within an existing building. Number 4 is the approval of the application submitted by HCM Architects to rezone the properties located at 3427th Avenue Northeast, 2601, 2629 University Avenue Northeast, and 2547 5th Street Northeast to construct a new street and equipment maintenance facility and garage for public vehicles. And number 5 is the approval of the application submitted by the Lander Group to vacate part of the alley in Block 17, Palmer's addition to Minneapolis, adjacent to 38th Street East Light Rail Station, subject to the retention of the easement rights by Excel Energy and CenturyLink. Are there any questions or comments from the committee members on these items, or would anyone else like to pull anything off for discussion? Also, let the record reflect that we've been joined by Councilmember Gordon. Not hearing any questions or discussion, I'm going to move that we move items 3 through 5. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. Let the record reflect that we've been joined by Council President Bender. And we're now going to move on to number 1, which is the public hearing regarding the 3 appointments for the City Planning Commission. The reappointment of Ryan Kronzer, the confirmation of mayoral appointments of Gene Coleman and Matt Brown for 2-year terms beginning February 1st and ending January 31st, 2020. I'd like to open the public hearing. Are the appointees here? We'd love to hear from you if you have anything to say. If not, we can move on to the other parts of the public hearing. Are there any other members of the public that would like to speak? Would anyone else like to speak? Seeing no one, the hearing is now closed. And with that, I move the approval of these 3 appointments. Is there any discussion? Council President Bender.
Thank you, Mr. Chair. I just want to take a minute to thank the folks who spend so many hours, as you now know, yourself as a Planning Commission member on this very important board in our city. And Commissioner Kronzer, who is here, he is our council appointee. My colleagues who've been here a while know that the architectural experience and expertise that he brings to this role is invaluable as we work to make sure that new buildings in our city are beautiful and well designed and reflect the neighborhood. And the other 2 commissioners who are being reappointed as well bring so much experience and value to this board. And we're just really grateful that people are willing to spend, up to 8 hours every 2 weeks just in the meetings themselves and many, many more hours preparing for those meetings. And it really makes a big difference in each of our wards in the community. So thank you.
Thank you. And I would just like to take this opportunity to second Council President Bender's words and also thank Commissioner Krosner for reaffirming all the work that he's already put in and look forward to your reappointment. With that, I'd like to move these 3 appointments for the Planning Commission. All those in favor say aye.
Aye.
All those opposed say no. And the ayes have it, and the motion carries. We will now move on to our quasi-judicial hearing. This is number 2, and we will be considering an appeal submitted by Nancy Alzek on the behalf of 3 Degrees Ministries regarding the decision of the Zoning and Planning Board of Adjustments to overturn the determination of the zoning administrator that 3 Degrees Ministry is a religious institution, place of assembly, and therefore does affect the spacing requirements for sexual-oriented use as outlined in section 549, 335, 350 of the Minneapolis Municipal Code. We'll begin with the staff presentation.
Good morning, council members. Item number 2 is an appeal of the decision of the Board of Adjustment regarding the spacing requirements of 549-350B. We'll go over the background here briefly. So in 2003, the zoning administrator determined 3 Degrees Ministries at the time to be a nightclub. They were operating a Christian nightclub at the time, and they had been granted a conditional use permit for a nightclub for extended hours, as they were a non-alcoholic nightclub. And then in 2006, 3 Degrees appealed the citing of a sexually oriented use that was within 500 feet of their location at the time. That went forward to council as part of the license application hearing, and council did agree with the zoning administrator's determination at that time. Then I will note that in 2008, 3 Degrees eliminated the nightclub portion of their use, reincorporated as a nonprofit, and that asserted that they met now the definition of a religious institution, place of assembly. The zoning administrator looked at the information that they had at the time, agreed with their assertion, and so we determined at the time that they were now substantially similar to or meeting the definition of a religious institution, place of assembly. So just as a note, in 2011, 3 Degrees Ministries moved to its current location at 119 4th Street North. And since that time, we have been applying the zoning administration office has been applying the spacing requirements from that location to any sexually oriented uses that could be have applied at that time. To begin this, in 2017, we denied a sexually oriented use portion of a Class A entertainment license at 415 First Avenue North. The applicant at that time appealed the zoning administrator's determination, and on March 1st, at its hearing, the Board of Adjustment granted the appeal 5-4, stating that 3 Degrees Church did not meet the definition of a religious institution, place of assembly. 3 Degrees Church appealed that decision, asserting that they are actually a religious institution, place of assembly, and we have that before us. So you should have all the public comments. There were additional comments submitted after the publishing of the report. Hopefully the committee has all of that. So findings for the staff are: the proposed use at 415 First Avenue South includes adult entertainment and therefore is subject to the spacing requirements of the sexually oriented uses. That 3 Degrees Ministries now meets or is substantially similar to the definition of a religious institution, place of assembly, and has been since 2008, currently located at 119 4th Street North since 2011. And that any possible entrance from 415 First Avenue North is less than 500 feet from any possible entrance at 119 4th Street North, therefore would be in violation of the spacing requirements. So staff recommendation is that the committee and council adopt those findings as stated and grant the appeal of 3 Degrees Ministries. Thank you.
Thank you. Is there any questions for staff? With that, before I open the public hearing, thank you. I'd like to give the appellant the opportunity to speak to the committee. Is there a representative from 3 Degrees Ministry here? And if you could state your name and address for the record.
Good morning, council members. My name is Carol Lansing. I'm an attorney at Faegre Baker Daniels. I'm representing 3 Degrees Church, also known as 3 Degrees Ministries. Nancy Alexuk is here, and she would like to speak to you after I make my remarks. I've put the definition at issue here on the screen. This is the issue before you, whether 3 Degrees Church is a religious institution, place of assembly as defined in the zoning code. Yesterday, I sent you a letter with the exhibits that support the conclusion that, in fact, it is. The religious purpose and affiliation of 3 Degrees Church is clear in the materials I've submitted and in the statements that have been made by Nancy to the Board of Adjustment. And it hasn't been questioned that they are religious affiliation. Its institutional status is also clear. I supplied you with the Secretary of State's record that they are incorporated as a nonprofit organization, and the Department of Revenue's letter that they have nonprofit tax-exempt status, and they exercise that as a religious organization. They have been incorporated with this status since 2007. Now, 3 Degrees Church is also a place of assembly. Their location, their current location, is a place of assembly for this religious institution. It's located in a space that it leases in a multiple tenant building. There's no dispute that this space is within 500 feet of the proposed location of a new sexually oriented use. The zoning code's definition of religious institution, place of assembly includes a church or other facility that is used for prayer by persons of similar beliefs. 3 Degrees Church uses its church facility for prayer and worship with people that share its Christian Bible-based beliefs. As you can see from the calendar of events that I submitted to you, There are multiple church services and prayer group meetings and other meetings of groups for spiritual purposes in that location throughout the week. 3 Degrees Church and the space it leases in a multiple tenant building is undoubtedly a place of assembly for religious purposes. There's no basis in the zoning code to conclude that it does not meet the definition of religious place of assembly because it does not occupy an entire building or a building originally designed for as a church or more traditional religious place. The zoning code does not define church by its physical characteristics. Now, this first clause, and I've separated it into 2 clauses because there's 2 clauses in this definition. The first one, church, synagogue, temple, mosque, or other facility that is used for prayer by persons of similar beliefs. There's nothing in that definition that requires it occupy an entire building or that it's in a building or that was designed for that purpose. And this is consistent with what we see more and more frequently in the city, that churches and organizations of other faiths are opening places of assembly and storefronts in non-traditional locations. And the code does include in this second clause, as a religious place of assembly, a building that may have been designed, or that was designed or particularly adapted for religious use, but it does not limit the idea of church or other facility to that particular use or type of facility. And the use of the code's term facility is in religious place of assembly is consistent with how the term facility is used throughout the zoning code. There are multiple types of uses that are defined as facilities. I included in my letter to you a list of some of those, several of them, and that's not all of them. For example, one is a sports and health facility. None of the facilities that are as uses in the code are required to occupy a whole building. The term facility is not used in that way. And in fact, many of those types of uses do occur in multiple tenant buildings. The city's 2006 decision, it supports the conclusion today that 3 Degrees Church in its current location with its current activities is a principal use and does meet the definition of religious institution, place of assembly. As Mr. Ellis described to you in 2006, 3 Degrees Church was an outreach ministry associated with another church, and its activity in it's called Club 3 Degrees, was as a nightclub with religious activities associated with it. At that time, the city determined that its primary use was as a nightclub and that religious activities were accessory. And it based its determination on that distinction between principal and accessory uses. In its current location, it does not operate as a nightclub. Its principal use is for religious assembly. It is in a multiple tenant building. Multiple tenant buildings have multiple principal uses. A tenant is not considered accessory because its space is smaller than any others. 3 Degrees Church does not meet the definition of accessory use, which I pull out 2 key characteristics: that an accessory use is incidental to and customarily associated with the principal use or structure served, and that it contributes to the comfort, convenience, or necessity of the occupants of the principal use or structure served. 3 Degrees Church is not incidental to any other uses in this building. It's not customarily associated with them. And although other occupants of this building, as members of the public, are welcome to come and be congregates, 3 Degrees Church is not accessory to those other uses in the building. And I'll note that in 2006, the City Council's decision did not focus on the fact that even at that time, 3 Degrees, Club 3 Degrees, was one tenant in a multiple tenant building. It was in an 8-story building. The findings did not say it's accessory because it doesn't occupy a whole building. It's not a church because it doesn't occupy a whole building. And applying this requirement, there was some discussion at the Board of Zoning Adjustment hearing about what is the purpose of this ordinance. The city recognizes that the downtown is going to be a place with the greatest range of uses, including sexually oriented uses. But it also recognizes that sexually oriented uses may have serious objectionable occupational characteristics, thereby having a harmful effect upon the use and enjoyment of adjacent areas. And special regulations are in place to seek to mitigate those potentially negative effects. And the purpose of the distance requirement is to provide a buffer between particular sensitive uses, religious uses, and those that serve children from sexually oriented uses. This buffer is not to protect the building from another building or an inanimate objects. It's about the impact on people who are going to these places. Nancy Alexic will tell you about why 3 Degrees Church chose to be in the warehouse district and why this spacing requirement is important to them. So in conclusion, since 2008, the city, as Mr. Ellis described to you, has recognized 3 Degrees Church, its location in a multiple tenant building, as a religious institution, place of assembly. We ask you to uphold that decision.
Thank you. I believe you had one other person you wanted to have speak.
No questions. Nancy would like to say a few words.
Yes, of course.
Thank you. Good morning.
Good morning.
Do I need to do anything special?
Now, if you want to just introduce yourself, it sounds like that'd be great.
Okay. So my husband and I are the pastors of 3 Degrees Church, and we've been a ministry and a church prior to our 15 years in the warehouse district. We were located in Northeast Minneapolis for about 14 years before moving into downtown. We did have two principal uses. The concerts and the outreach that we ran was definitely in the forefront of the public eye. When we moved and were looking for larger facilities, we really felt that our mission as a church to take the gospel to places in our city that are typically underserved where church uses are concerned really weighed in on our decision to look for space in the warehouse district. We felt that both of our uses as a church and as a concert ministry would be complementary in that area. However, we were very mindful of the spacing requirements. I, in particular, spend a lot of time ministering to women and have for the past 30 years, and am very sensitive to women in particular that have come out of abusive situations, sexual abusive situations, and as well as the adult entertainment industry. While I respect the rights of individuals to operate those businesses and for people to patronize those businesses, there is a downside and a dark side to that. And it is uncomfortable for women to feel confronted by that use. And so we were very specific in locating our ministry and our church in an area where there would be accessible parking, people could take public transportation, walk, bike, come to church in kind of a safe, protected area. And so our first location was on 5th Street, right next to Ramp B. And at the time, Rapid Park was still there, so there was kind of a clear path of travel that direction, the bus stop and 1st Avenue. And then in our current location, we're on the corner of 2nd Avenue and 4th Street. A lot of our families that drive in, so we have quite a few members in our congregation live in Minneapolis. They take the bus, they take the train, they walk down 1st Avenue to get to church. The proposed strip club location is right there. You get off the train station and a lot of the ladies will sit more towards the front of the train so they can get off closer to the corner and then walk down 1st Avenue as opposed to sitting in the back of the train where they're getting off and walking by Dream Girls. So it's really, to me and to us, about protecting their rights as well. The city has a long tradition, and a lot of cities have traditions of enforcing or having those spacing requirements, and we believe that the rights of parents with young children that park along 1st Avenue or park along 2nd Avenue should be able to get to church without being confronted with sexually oriented use.
Thank you very much. Are there any questions? Oh, thank you again for testimony.
Thank you.
Considering we've heard from the appellant, I'd also love to give the applicant the opportunity to present to the committee. Is there someone here to speak?
Thank you, members of the Planning Commission. My name is Dennis Johnson. I'm with Chestnut Cambronne Law Firm. I represent Peter Hafetz, who's here with his daughter. As you may know, Peter owns about 7 establishments in downtown Minneapolis, employs over 400 people. Is very familiar with downtown Minneapolis and has been a good business person for Minneapolis. But that is not the issue here today, nor is the issue in my mind whether or not 3 Degrees is actually a church. We're not disputing the fact that it's a legitimate ministry. We're not saying that they haven't filed the proper documentation. I think what the original zoning decision, as I read it when we went to the Board of Adjustment, focused on whether or not 3 Degrees was a church. I don't think it focused on the definition of religious institution, place of assembly. The definition, which was, I don't disagree with a lot of things that Ms. Lansing said, except that when you look at the definition of the religious institution, place of assembly, you have to read it in terms of statutory construction and how you have to read statutes and ordinances. And clearly there's a body of case law that says when you look at a definition, you have to use the normal meanings of words. And if you have any question about a normal meaning of a word, you have to look at the preceding words or the subsequent words in that definition. I don't think anybody can dispute, I think a common sense look at this definition says that the 4 buildings identified in the first part of the definition, church, synagogue, temple, mosque, really deal with mainstream religions that we're all very familiar with. The second part of that definition, or other facility, has to relate back to what they referred to in the first part of the sentence, and that's buildings, that's a church, synagogue, mosque, temple. They're not talking about organizations, they're not talking about Catholicism, they're not talking about Jewish faith, they're talking about actual facilities, buildings, and then they refer to another facility, and I think the best way to talk about that would be if there was the Church of Denny or 3 Degrees. If they had a specific institution where they had a freestanding building, I think that is what this is meant for. It's not meant to preclude someone from putting in a business with someone who has 6,000 square feet of a 112,000 square foot building in downtown Minneapolis. If you also look to this.
I believe we have a question from Councilmember Goodman.
Yes.
I'm sorry, but I'm just not sure I understand exactly what you're saying. So let me rephrase it in real people's terms, and you can tell me if I'm incorrect.
Okay.
We think they're a church, but we don't think they're a church under the code because they don't have a building that makes them a church separate from itself, and that we should define them as not a church because they don't have a building that's separate on its own. Is that essentially your argument?
No,
Help me understand it.
That's not my argument. My argument is they're not a religious institution, place of assembly as defined in your code. They're a church. I have no problem with that as far as what they have filed and what they do, and no different than the Catholic Church. However, they do not come under the definition that this city has defined as a religious institution, place of assembly, based upon how it's set up in the code and how it's defined in the code. That's what my argument is.
Yeah,
and I believe that's.
I'm not sure I even understand that. They're not a religious place of assembly. Why?
Because they don't fit into the definition that this city has set forth in their own code, which relates to specific buildings or a special purpose building specifically designed for people to come together in the same faith. I'm saying that that's what this code was designed for. It was designed for people who put in a storefront ministry all around town, keeping in mind that downtown Minneapolis is the only place where you can put sexually explicit entertainment venues, and that's been zoned, and that was decided by the Supreme Court years ago. And so now you would have people putting up all kinds of you could have them put up just a storefront, and that precludes people from putting in other businesses. I don't think that was the intent of this statute.
No, I think it actually was the intent, but that happened before I got here. I have a business that used to be in my ward called Corner Coffee. It's in the North Loop right now. They are in a commercial building. They sell coffee. They have ministry on Sundays. They do a number of other counseling, pastoral counseling, religious things throughout the year. Would you suggest that they're not a church or a religious place of assembly under our code?
Your Honor, as it relates to the...
Councilmember? That's okay.
Excuse me, Council, I did that before.
No one would ever refer to me as Your Honor, trust me.
As it relates to the 500-foot requirement, yes, I would suggest that that would not apply, as it relates to the definition that we have.
That would be your argument.
Correct.
I don't think that's a winning argument, but you can continue to make it. I personally think this line of argument is just not legitimate at all. So keep making it, but you haven't been able to convince me. And I'm empathetic and sympathetic to the applicant, but if that's the argument, I don't see how we would ever agree to that.
Your Honor, people of the council, then the other thing I would point out is that if you go to the second part of the definition, it also relates and talks about buildings specifically designated where the primary purpose is bringing people together of the same faith. I would contend that a 6,000 square foot leasehold on the fourth floor of a building does not fit this definition. And I appreciate the comments, but I guess I would stick to my argument that the definition that's defined in this particular code does not preclude the Havenses from putting in the establishment where they seek to put it in.
Mr. Chair, could you have Mr. Nilsson, our attorney, give us his analysis of that legal opinion?
That's a great suggestion.
Chair Schrader, Councilmember Goodman, you stated it correctly. The zoning staff in their report stated it correctly. A multi-use building can have multiple principal uses within it. And just because there are principal uses in this building that are separate leaseholds does not make one particular use, regardless of the size, does not make that particular use accessory to the other use or somehow accessory to the building as a whole. And in terms of the definitions and statutory interpretation, Mr. Johnson's correct about the principles of statutory interpretation, but in this case, the definition the two clauses of the definition are separated by an or. And so you don't have to meet both. The portion of the definition at issue is just the first portion, which was the portion discussed by Ms. Lansing, and that does reference other facility. And as the staff stated in their findings, that the code does not regulate the nature of religious practice, but it does regulate where it can occur. And so that's the intent behind the definition.
Thank you, Mr. Nilsson. Mr. Johnson, do you have anything else to add?
Good morning, members of the Zoning and Planning Committee. My name is Gary Schiff, and it's good to be here with you all this morning to talk about this issue that I have spoken about previously in these chambers and that the City Council has previously ruled on. There is precedent for the City of Minneapolis to decide that 3 Degrees Ministry does not fall under definition of a religious place of assembly and indeed was a nightclub. That happened in 2006. At that time, their activities were looked at, their marketing materials were looked at, a decision was made, and on a 10-3 vote, the City Council agreed that they were more closely associated with the definition of a nightclub. Now, they have changed their business practice since then. I don't think they still host touring concerts and shows as much as they used to or make cover charges. So it does come down to plain word definitions, and I want to walk you through this very clearly because for me, this is a very easy, clear decision when looking at the intent behind these words. First, as Mr. Nilsson said, the second half of this sentence does not apply, and I agree it doesn't. And here's why. This is the facility that we're talking about. If you can zoom in on that. This is photos from their Facebook page showing the building that they're in and the space that they have. This was dated 2014 on their Facebook page. And when you see the photos of the rest, you'll see drywall, you see the original posts of the building, you see standard HVAC, standard overhead lighting, you see chairs that are movable, you see plastic podiums, So clearly, I think these photos show that we are not talking about a specially designed facility that has been architecturally designed for the purpose of conducting regular basis religious services. It's a nice space. Don't get me wrong. It's a nice space. But under our definition, we're talking about a special purpose building architecturally designed. Mr. Nilsson pointed to the word or, and I want to point out that the word or is a conjunction that introduces a synonym or explanation of a preceding word or phrase. It doesn't have to be an alternative. It means or in other words. It doesn't need to mean or in contrast to. So right there, or is a conjunction introducing a synonym or explanation of preceding words or phrases. And obviously, when we're defining a use, we don't want to send conflicting messages. You don't want to have a definition that says, well, you could be this or you could be that. What you want to do is send a very clear, specific construction that says, here is what it is. And you want to use examples for what it is. The appellant today is trying to use the word facility to tease that out, to say that means any space where religion is practiced. That is not what your zoning code intends. In fact, after the zoning code was adopted and these definitions were adopted, the law known as the Religious Land Use Act was passed by Congress, signed into law by President Bush. The Religious Land Use Act explicitly prohibits local governments from regulating religious activity in their zoning code. I want to repeat that. The Religious Land Use Act prohibits us from regulating religious activities in our zoning code. So nothing today says 3 degrees can't exist. Nothing today says they can't continue what they're operating. What we're here debating is whether or not the constitutional guaranteed right in the 1972 Supreme Court case, California versus LaRoe, that said that stripping is a form of protected free speech, whether or not the Constitution gets suspended in a 500-foot radius because a religious organization has rented a space in a building. That is nonsense. The U.S. Constitution does not operate in little circles where wherever somebody moves, it gets suspended. And so I do want to point to the example that Councilmember Goodman mentioned. We have ministries throughout downtown. We have all sorts of faith-based organizations. We have chapels. We have all sorts of things in other buildings, but that doesn't meet this definition. The first 4 words are building types: a church, a synagogue, a temple, or a mosque. One of the exhibits that we used at the Zoning Board of Adjustments public hearing was what happens when you go to a good source of common language, Google. What happens when you Google these images? And it's pretty clear that church is meant to be a building. When you Google church, that's what pops up. Pictures of a mosque. Pictures of a synagogue. These are building types that are being regulated. The zoning code used to refer to ministries. It used to refer to a whole lot of other religious activities. That was taken out in the 2001 definition when the definition was updated. It used to just say churches, and it was made to be more culturally inclusive of other building types and other major world religions. It was never expanded to incorporate all religious activity wherever it's practiced in any form. And for good reason. The definition of what is a religion is getting changed every single day. Our country has a history of new religions being formed. Perhaps some people in this room have gone to the Universal Life Church Christian Academy online and become an official minister and able to perform weddings in the state of Minnesota. So again, we're not here to judge whether or not this is a legitimate ordination certificate and whether or not somebody ordained in the Universal Life Church is legitimately a minister, because the zoning code doesn't regulate that type of religious activity. We don't want to go down this road of who's legitimate and who's not legitimate. In the original staff presentation, the Zoning Board of Adjustment staff made a statement that I think is very, very problematic for staff's position. And that was, we generally agree and I want to make sure to get the direct quote from Mr. Ellison's staff report directly so I don't misquote him. But it's along the lines of, you're a church if you say you're a church. We accept people at face value if they say they're a church. Well, you'd have to change your zoning code definition to match that. You'd have to say this category is open to anyone who claims to be a church. Then we wouldn't be here today. Or you could say the definition applies to anyone who's filed as a nonprofit in St. Paul. That could be your definition, but it's not there. The city council has ruled consistently that this has not been seen as a religious place of assembly, third degrees, in the past, and it's even less so today because they are simply a tenant, they are mobile, they move. And constitutional protections cannot be summarily changed with a lease from somebody who is, frankly, gaming the system, moving into the only district where adult uses are allowed, and then seeking to repeal and repel those uses from their radius. The phrase of a clear path of women who are coming to the church must be met has been said. There is no clear path. Anybody getting off that light rail, even blinders wouldn't help to avoid the fact that you are now in an adult entertainment district. This idea that people deserve to have anything that they find offensive or anything that they find against their religious morals is not the basis of zoning code regulation. That's not what this is intended to do. It's intended to protect people who've invested in a neighborhood. That's the basis of property rights. That's the basis of the whole zoning code, is to protect people who've invested in these buildings. Again, not religious spaces. There's nothing here that says any space where people pray is a religious place of assembly. That's not the definition. I heard Councilmember Gordon mention the word facility. Does that. The word facility, as used by facility management people, is meant to refer to a building. The word facility refers to a building. It's in context with the rest of the words. We cannot pull out one word here, apply a different, broader definition of it, and then say all the rest gets thrown out.
Thank you, Mr. Schiff. I've got a question.
Sure.
So when you talk about the city council formally ruling that 3 Degrees was not a church at that time, had they registered with the state?
I don't know what their incorporation was. As you know, we don't have any formal recognition of religion in the United States. So there is no formal state registration of religious churches. A church can choose to incorporate as a nonprofit. And in fact, it's the nonprofit articles of incorporation that are cited in the staff report as evidence that they are a church. Whether they're a for-profit pyramid scheme, as some religions are, or whether they are a nonprofit religion is immaterial to the zoning code today.
But you also mentioned that now they have registered as a nonprofit.
Now they're a
and they have
nonprofit in
done
the state of
that.
Minnesota. And you can as you go through the comprehensive plan work in the year ahead, you can update your zoning code and you can change the definition to make it more clear in the future. And we won't be here arguing this point. If you say, as long as you claim to be a religious place of assembly and you are incorporated as a nonprofit or for-profit, then you qualify for the spacing rule, then that would settle this issue. But until then, we've got this definition on the books, and it specifically speaks to buildings.
Okay. Thank you, Mr. Schiff. Are there any other questions from the committee? Oh, seeing none. Thank you. With that, I'm going to open the public hearing. Is there any members of the public that are going to speak? And I'd also like to note that we'll be using the timer as well. So please come forward, state your name and address for the record.
Chair Schrader, members of the committee, council members, my name is Dan Collison, senior pastor of First Covenant Church located at 810 South 7th Street. And I have served in that capacity for close to 9 years, as well as partnered with the interfaith coalition called Downtown Congregations to End Homelessness. And I've been a pastor for more than 25 years. I'm here out of deep concern that 3 Degrees Church, located in the Warehouse District, is having their status and rights as a church challenged on the grounds of being located in a multi-tenant commercial building. There are religious institutions of many kinds with places of assembly across the entire city that are in diverse building typologies ranging from schools, coffee shops, event centers, and commercial spaces. To name a few, the Minnesota Buddhist Center is located at 1201 Harmon Place, 55403, in a corner retail space of a 2-store half-block commercial building. Corner Church, as mentioned by Councilmember Goodman, is located in North Loop at 514 North 3rd Street on the ground floor of a multi-tenant commercial building and a coffee shop. Masjid Dar al-Hiraj Mosque and Islamic Civic Society is located at 500 Cedar Avenue South, directly adjoining the Palmer's Bar and Andrew Riverside Presbyterian Church at 403 Southeast 8th Avenue near the University of Minnesota on the ground level of a large multi-family housing project. And I might add as well, the description of 3 Degrees Church of having a podium and drywall and entrances looks exactly like the inside of First Covenant Church that just has a different skin. And that in the times we're in, even churches that have largely gone empty in some spaces have become host to commercial and nonprofit spaces. There's an intermingling, and it is about real estate, and yet this conversation is not as much about real estate as it is religious assembly. And in my opinion, and on a personal level, having known of the Alexux and 3 Degrees for nearly 2 decades and 15 years as this unique congregation, that it's an asset, and I'm troubled that it would be called into question. And I ask to see this overturned so that they may continue their work according to statute.
Thank you very much. Is there anyone else willing to speak? I guess willing's the wrong way to put it. Is anyone else interested in speaking? Seeing no one, I'm going to close the hearing and see if we have any discussion among council members. All right, seeing none, I'd be open to someone making a motion, or I will move myself that we accept staff's recommendation regarding the decision of the zoning board to overturn their zoning board of adjustments. And I look to see if there's any second discussion. Councilmember Gordon.
I just speak in support of that. I did really appreciate the arguments and the efforts to make the case for why the spacing requirement shouldn't apply here. But I think that they're wrong. When I read the language, it's really clear to me that it could be a church or a mosque or a synagogue or something else or a facility. I actually took it upon myself to Google images of facilities. You see little sports places inside large buildings. You see little laboratories and classrooms that are inside office buildings. The facility is clearly intended to mean a variety of things, including a portion of a building and even less than that. I also looked up the definition, and it talked about spaces and places. And so it's definitely very loose, and it's very clear that it doesn't have to be a mosque and a church and a synagogue and a facility, or that it has to be a standalone building. I also think that if it's supposed to protect the neighborhood amenities or people who bought real estate in neighborhoods, well, our downtown is getting to be more residential and more like a neighborhood. And I'm sure there are businesses down there who consider it a neighborhood, and they've probably even given it a special kind of a name. So I think that if we're going to apply this, it has to be clear. I'll also note that I was here earlier when we weren't sure about what this 3 Degree was, and we did look up their promotional material, their calendar, all its information that's available now, and it looks very different now. What you see when you look up and you look at the images and the calendar and what they're doing. It doesn't even appear they do concerts of any kind anymore in their facility. So I think that it clearly has changed.
Thank you. Council President Midner.
Thank you, Mr. Chair. I don't want to belabor this, but I think this is just such a clear case of a religious institution. The calendar is filled with Bible studies and services and a very traditional definition of what we imagine a religious facility to be. And I think it's important because, I can think of a number of places in my ward that weren't mentioned yet as examples of religious institutions that are, a mosque that's in a commercial building or a church that meets in a coffee shop. If we were interested in protecting the downtown space as a place for adult entertainment, we would have to change our policy to do that. But the policy is very clear to me that we have the intention of the policy is to create spacing, and this is very clearly a religious institution. So I'm very supportive of the motion by the chair.
Thank you. Councilmember Goodman.
Thank you, Mr. Chair. I also agree this is a religious institution, place of assembly. And I think the only difference between all of the other arguments that have been made is that sexually oriented use is already concentrated in one part of town. So by saying there's additional spacing requirements, like Club 3 Degrees is within 1,000 feet of residentially zoned areas. There's a church on Hennepin on the border of Councilmember Bender and my ward. That's also within 1,000 feet of a residential area, and sex uses are not allowed in any of those areas. And so I think we have this careful balancing act to not amortize out these businesses despite our distaste of them, and be careful to allow them to operate in certain areas. It might bring to question whether or not we should have a spacing requirement for religious places of assembly from sex uses, given the amount of space that sex uses are already allowed. Remember, they're not allowed even in most of my ward now. It's mainly in Councilmember Fletcher's ward. So the amount is being constantly restricted. So to have a spacing requirement could prove to be problematic. That is probably a question for another day. But that's what kind of comes to mind to me as the bigger problem, is that they're not going to be in the North Loop. They're not going to be in Loring Park. They're not going to be in Uptown because they're not allowed there. But this is the area where they are allowed. And I'm sure the reason we have not made changes to our code is this area is fraught with litigation. And anytime we make one move in one direction, we're sued in another. And so in this particular situation, given the code that we have adopted, I believe we can judge that this is a place of religious assembly and it's not allowed under the code. That does not mean the code couldn't or shouldn't be changed moving forward. And I want to make sure that the applicants are aware of that, because it might mean that a change needs to be made at some time.
Thank you. Councilmember Reich.
Thank you. I think I will concur with some of the points being made. I think Councilmember Goodman does bring up a broader conversation that's timely. We are looking at our comp plan. And I think when you have one very circumscribed set of protections in terms of a very restricted area for certain uses, that is the single protection that you might use. Because Mr. Schiff brought up really good arguments. So we can, practically speaking, find difficulties that are actually way more intrusive in our restrictions than what we intend. And I think to that extent, that practical extension of our policy, which is unintended, we should be looking for corrective action, or at least contemplating that dynamic. I'm not necessarily trained in the sophisticated semantics that were brought up, but in my days of watching Schoolhouse Rock, the conjunction or does create a this or that dynamic. So I'll be going with the prevailing motion before us.
Are there any other questions from council members? Well, I'd also want to just give some explanation why I made the motion. I also feel the code is very clear cut. I am also, as a person of faith, I think we have to be very, very, very careful about questioning and saying what is a religion and what is not. I think that I also concur that Mr. Schiff brought up some great points about our current zoning policy and what that could mean. So with that, I'm going to renew my motion and ask all those in favor to say aye. Aye. All those opposed say no. The ayes have it and the motion carries. Seeing no further business before us, we are adjourned.